Let's go to the topic on wages. This is a good source for bar examination also. So if you will be asked to define wage, all you need to do is enumerate the characteristics under paragraph F of Article 97 of the Labor Code. So what are these enumeration? First, you have to remember that a wage is a remuneration or earning qualified by the Labor Code, regardless of designation or however designated. So this is an earning or remuneration, no matter how you call it, for work done or to be done or service rendered or to be rendered. Another characteristic of wage would be that it is capable of being expressed in terms of money, whether fixed or certain on a time, task, piece, or commission basis or other methods of calculating the same. Another characteristic of wage would be that it is payable by the employer to an employee under written or unwritten contract of employment. And finally, it includes the fair and reasonable value as determined by Secretary of Labor of the board, lodging, and other facilities customarily furnished by the employer. So we are talking here of facilities as included in the definition of wage. So if you will be asked define wage, you give and enumerate the enumerations that I gave under paragraph 7 of Article 97 of the Labor Code, or paragraph F, not 7. So the enumeration is there. That enumeration will give you the characteristic of wages. Now, the common question in bar examination would be facilities. The very easy question would be distinguish facilities from supplements. Okay. So let's discuss first the nature of facilities. Now, what are these facilities? So before the employer can deduct facilities, the case of Mabisa versus NLRC, April 18, 1997, the Supreme Court enumerated the requisites before you can deduct facilities. One, that it is customarily furnished by the trade of the employer. It provides then the provisions of deductible facilities is voluntarily accepted by the employee in writing, and it is charged at fair and reasonable value. So we don't have the problem with the first two requisites. The problem now is the third requisite. When can you say that is fair and reasonable? In order to determine that it is fair and reasonable, then we already have the department order for that. Department order number 126-13. That department order will tell you how to determine whether it is fair and reasonable. So the employer, in order to qualify the charge or to qualify the amount charged by the employer, for example for food, because food is considered a facility, the employer will file it before the RTWPB having jurisdiction over the workplace, and it's the RTWPB who will determine and approve on whether the amount is reasonable. So there is the relationship here between the RTWPB and the regional director, because the RTWPB will coordinate with the regional director to conduct the meeting on the facility evaluation. So this department order already enumerated what are facilities and what are supplements. In summary, these facilities are necessities that the employee will still spend, no? So since the employee will still spend for it, it is much better if the employer will just provide and deduct. However, you have to comply the requirements. So if you will be asked what are the distinctions, no, of facilities and supplements, facilities can be deducted from the wages. Supplements are not, because these are not necessities. Facilities benefit the employees. Supplements, they benefit the employer. However, there is an exception. So when it comes to food or meals of members of the vessel or the crew members of vessel, seagoing vessel, the food provided there is not considered supplement, but it is considered facility. In the case of State Marine Corporation and Royal Line versus Cebu Seamen's Association, February 3, 1963. No? It was an old case, but the Supreme Court said that doesn't mean that meals are considered facilities. So what will be the questions that you expect in bar examination? The easiest one would be distinguish facilities from supplements. So that's how you do it. One facility is deductible, supplement is not. Facilities benefit the employees, supplements benefit the employers. And before you deduct facilities, there must be the requisites that you comply, no? And this facility should be determined and approved by RTWPB to be fair and reasonable. Those criteria, latter criterion, are not found in facilities. After all, you cannot deduct it from the employee's wages. So if ever there is a question asked whether or not meals given to crew of seagoing vessel, whether they are considered facility or not, then that is the exception to the rule, that it is not considered facility, because although food is a necessity of the employees, but in that case it benefited the employer. The crew members doesn't have to dock their vessel and eat lunch, dinner, or breakfast. So that is the reason there. Another topic, or I think is a good question also, and it has been asked in the bar examination, is that you have to distinguish between wage and salary. What is the purpose of distinguishing that one? Not so much on its nature, because you know that wage is different from salary. Because when you talk of wage, this is compensation for manual labor, skilled or unskilled workers. Whereas salary, it connotes or denotes a higher degree of employment or a superior grade of service. So the relevance here is not only on the basic distinction, no, on wage, but when it comes to attachment or execution of judgment. Because when you talk of Article 1708 of the Civil Code that governs attachment on wage, when it comes to wage, it can only be attached by a judgment or subject to execution if the decision or order of the court is based on debts incurred for food, shelter, clothing, and medical attendance. That's the only instance when you can attach wage. On the other hand, if you are talking of a salary, there is no limitation as to what can be executed against it. So, all kinds of judgment. The reason behind is to protect the wage earners, because wages are lesser in terms of amount compared to salary. So, the reason for that is equity. It is unfair on the part of the wage earner. If you're going to execute any judgment, then the net pay will be very minimal already. It cannot feed the family. So that's how to distinguish wage, no? In order to distinguish wage from salary, first you start with the nature of wage, to whom it is paid, no? For manual skilled workers, and you also have the salary paid to employees who have higher degree of employment or superior grade of services. And on the other hand, you make the distinction also when it comes to attachment or execution of judgment. So if it is wage, you can only attach or execute a judgment for debts incurred for food, clothing, shelter, medical attendance. If it is salary, you can attach anything as long as there is a court order. So let's go to the basic principle in wages. First, we are talking here of Article 100, no, of the Labor Code. It's the prohibition against elimination or diminution of benefit. Employees, they also receive wages, and they also receive other amounts, no, which are considered supplements. Article 100 deals with the prohibition against diminution of benefit, not diminution of salary, because we are talking here of supplements and other benefit. So we discussed already supplements, no? Those are given by the employer, although not a necessity, but given by the employer at the time of the promulgation of this code. So you cannot diminish that one. That is the non-diminution of benefit. So never commit a mistake that you will say diminution of wage. It's not. Article 100 deals with diminution of supplements, not wages. Diminution of supplements and other benefits. So that's why the relevance of distinction between supplements and facilities. So the reckoning point here is that these benefits are already enjoyed by the employees at the time of the promulgation of the code. And the giving of this benefit should follow the following requisites. No? According to the case of TSPIC Corporation versus TSPIC Employees Union, February 13, 2008, the Supreme Court made the following ruling. There is diminution of benefit when it is shown that the grant of the benefit is founded on a policy or has ripened into a practice over a long period. No? It is not a grant by accident or mistake. Then this practice is consistent and deliberate. Another, the practice is not due to error or construction application of doubtful question of law. This is what I mentioned earlier. And the diminution of discontinuance is done unitarily by the employer. So those are the requisites if you want to lay down the rule on diminution of benefits and supplements. So the other principle which I discussed earlier is the prohibition against attachment under Article 1708 of the Civil Code. We already discussed that. You have the case of Rosario Ega versus Honorable Court of Appeals. So in that case, there was a garnishment against the salary. So the employee objected because according to the employee is exempted from execution. According to Supreme Court, the distinction between wage and salary came into play. So since the employee here earned salary, so the judgment can be executed. Another principle when it comes to wages would be equal pay for equal work. This was initiated in the landmark case of International School of Alliance of Educators versus Kisumbing, June 1, 2000. If two employees perform the same kind of work, regardless of their qualification, the employee should be paid equally. So, in this case, the foreign teachers were given higher salary according to that case, because the rationale of the school is that since it is an international school, they need foreign teachers. So to attract foreign teachers, they have to give higher salary. However, the foreign teachers are teaching the same subject with their local counterparts. However, they earn higher salary. So the case went up to the Supreme Court, and the Supreme Court used the principle, no, of equal pay for equal work. However, when it comes to educational institution, since there is a basis for classification when it comes to academic achievements of professors or teachers, so there's a valid distinction here, no? When a professor or a full-fledged professor teaches the same subject with that of a lecturer or an instructor, by reason of the achievements, educational achievements of the professor, the salary of the professor is higher. So that is an exception when it comes to educational institution, because there is a valid basis for distinction of salary. The work performed are the same, but we are talking here of higher educational institution where there are employees who hold PhD degrees, and in their salary level they receive higher wage. They are paid of their salary because of their educational attainment. So a professor earns a higher salary or is paid higher compared to an instructor, although they might teach the same subject. Definitely a professor can share more knowledge than an instructor. So that would be the basis for distinction of equal pay for equal work. Another example would be, in College of Law, there is a university in Cebu City that pays 100 peso higher per hour to faculty handling review classes compared to a faculty handling non-review classes for equal number of units, because of the nature of work required, when you handle review classes. But generally, equal pay for equal work applies to two workers performing the same kind of job with the same qualification. They should be paid equally. So it will not prevent the company from giving higher pay to employees who have educational attainment or further studies, especially in educational institutions. Another principle is a fair day's wage for a fair day's labor. So if there is no work performed by the employee who is willing to work, but it is prevented from working due to illegal dismissal or any other circumstances or lockout, then the employee should be entitled to wages. Another circumstance also that this fair day's wage or fair day's labor will not apply is in the case of regular holidays or leave with pay. So if the employee performs work, then the employee deserves to be paid. Even if the employee wasn't able to work but he is willing to work, but because of illegal dismissal and lockout, then the employee should be paid. The only exception when the employee who is not working is paid is when the rule on legal holidays apply and leave with pay. So far, those are the principles regarding wages. Now, how do we fix the compensation? So here we have the methods of fixing compensation. The rule here is this method of fixing compensation is nothing more but just to fix the compensation, whether based on time or the time spent, commission, task, fees, or other method. The Supreme Court, since it emphasizes the fourfold test, the fixing of compensation doesn't mean or cannot be used as a gauge to determine the existence of employer-employee relationship. In the case of Bitoy Javier versus Fly Ace Corporation, February 15, 2012. So never you use the method of fixing compensation to determine the existence of employer-employee relationship. It's only a method of payment. Now, under RA 6727, or otherwise known as Wage Rationalization Act, it is the Regional Tripartite Wages and Productivity Board of every region that fixes the minimum wage. It used to be before a legislated wage. Congress enacted law regarding wages applicable nationwide. But with the passage of Republic Act 6727 in June 29, 1989, it's now the Regional Tripartite Wages and Productivity Board. As to whether or not who can petition, you have the board. Motu proprio can file petition, or it could be filed by a labor organization or any employer who has substantial interest in the region and stands to be directly affected. Regarding the prohibition on injunction under 126 of the Labor Code, the prohibition of injunction covers the Regional Tripartite Wages and Productivity Board, including the National Wage Commission, National Wages and NWPC, National Wages and National Productivity, NW, National Wages and Productivity Commission. So that's Article 126. No preliminary or permanent injunction or restraining order may be issued by the court or tribunal against any proceedings before the commission or the regional boards. If you will be asked on the factors in determining or fixing the minimum wage, you just enumerate, but these are not hard and fast rule. These are just factors for consideration. After all, the voting is the final determination. If you want to appeal the wage order, then you will appeal that to the commission within 10 days, not later than 10 days from the date of publication of the order. You have the grounds for your appeal. You remember, you have to accompany that with memorandum on appeal, and the grounds would be non-conformity with the prescribed rules and procedures, question of law, or grave abuse of discretion. Then the commission has the period of 60 days to decide. However, the appeal does not stay or operate to stay the order unless the party appealing such order shall file commission an undertaking with a surety or surety satisfactory to the commission for the payment to employees affected by the order to the corresponding increase in the event such order is affirmed. So the order of the Regional Tripartite Wages and Productivity Board will become effective 15 days after its publication in at least one newspaper of general circulation in the region. So it's 15 days. However, a good question here when it comes, other than determination of minimum wage, another good question would be wage order compliance, exemption. So who are exempted from complying the minimum wage order of RTWPD? You have your distress establishment. All you need to do is just enumerate. Then you also have new business enterprises, then retail and service establishments employing not more than 10 workers, Then establishment adversely affected by natural calamities. Then you also have the Kasambahay law, this domestic workers exempted. Article 98 of the Labor Code, farm tenancy or leasehold, domestic service and persons working in respected homes, in needlework or any cottage industry. Then employees of barangay micro business enterprise under RA 9178 of 2002. Then you also have the apprentices under Article 61 of the Labor Code, because they are paid not lower than 75% of the applicable minimum wage. Same is true with learners under Article 75 paragraph C, and handicapped workers. However, you have to remember that the exception here is not presumed, so the employer must secure certificate of exemption from the Regional Tripartite Wages and Productivity Board, so that when the labor inspector will visit the place or inspect the premises, then there will be no order of or notice of non-compliance. Okay. The very favorite question in bar examination is wage distortion. So you will just be asked, when is there wage distortion? So you have the landmark case of Pro Banker Association versus Prudential Bank, January 25, 1999. According to Supreme Court, wage distortion is a situation where an increase in the prescribed wage results in the elimination or severe contraction of intentional quantitative differences in wage or salary rates between and among employee groups in establishment as to effectively obliterate the distinctions embodied in such wage structure based on skills, length of service, and other logical basis of differentiation. This is the question of fact for the Supreme Court. So basically, there is wage distortion where there is the reduction of the significant gap intentionally made under the wage structure. So what is wrong here is the wage structure of the company, because if the company is not wage distortion proof, then the prescribed wage increase will definitely result to wage distortion. So if you have a simplified wage structure, you only have two groups, rank and file employees and supervisory employees. Your rank and file employees receive the minimum wage of 404, for example, in Cebu City, and your supervisory employees receive only 410, and they are supervisory employees. If there is an increase of 10 peso, then the probability would be the intentional gap would be eliminated. So the supervisor now will earn a lesser salary compared to rank and file. And when it comes to exemption from minimum wage, between the two groups, the rank and file employees will bring higher net pay compared to supervisory employees. So it will lead to wage distortion, and this is supervisory employees will feel disgruntled, they'll be frustrated. So it has a bad effect on the company. So we have to resolve this one. So that's wage distortion. Now, there was a question in the bar examination, because there are two methods that will minimize wage distortion. So the floor wage method and salary ceiling method. According to Supreme Court, the salary ceiling method minimizes wage distortion than floor wage method. If you will be asked to distinguish between floor wage method and salary ceiling method, you just go to Metrobank Incorporated versus National Wages and Productivity Commission, February 6, 2007. According to Supreme Court, the floor wage method involves the fixing of a determinative amount to be added to the prevailing minimum wage rate. So if the minimum wage rate in Cebu City is 404 and there is a 10 peso increase, using the floor wage method, you will add 10 peso to the prevailing minimum wage rate. So those who are earning minimum wage workers, they will receive 10 peso increase. On the other hand, the salary ceiling method, the wage adjustment was to be applied to employees receiving certain denominated salary ceiling. For example, the wage order will specifically state that those who are earning only below 404 shall be entitled to salary increase. So those who are earning only 400 peso or 390 in Cebu City will receive the minimum wage. So with that, it will not result to wage distortion, because as what I cited earlier, if you increase minimum wage to a very simplified wage structure where the only difference between the salary of the supervisor or the wages of supervisors and the employees would only be 10 peso or 10 pesos, and there is the wage increase. If you use the floor wage method, you add that to the minimum wage earners who are earning 404, then the minimum wage per day of the rank and file employee would now be 214, and the supervisor would only be earning 210. So there is now obliteration of the intentional gap as to wage structure. I mentioned earlier that there is what we call salary structure wage distortion, salary structure that is wage distortion proof. So the company can already make a substantial difference of wage gap. So for example, you have to make a gap of 50 peso between the minimum wage earner and the supervisory workers. So there's a gap of 50 pesos. So no matter how many increase would be imposed, there will be no obliteration. Or to be safe, if there is an increase of wage, so the supervisory employee should be given additional increase also. Although they are not covered by the minimum wage, but they can be given increases also, subject to the discretion of the employer, to avoid wage distortion. So that was asked in the bar examination, distinguish floor wage method from salary ceiling method. And other than from the distinction, you will also add another distinction that the salary ceiling method minimizes wage distortion in the case of ECOP versus NWPC 201 SCRA 759. So that's the very important discussion on wage distortion, and I hope that you can answer. We will stop from here, and the next video clip will start with form and payment of wages.